And we are here, my notes say we're here on a motion for summary judgment. Is that correct, or is it something else?
No, Your Honor. As far as I know, two of my motions are noticed for hearing today. It's my motion for leave to conduct limited discovery and my motion to strike affirmative defenses.
Okay. Counsel, is that your understanding?
Yes, Your Honor.
Okay, I just had, I'd gone through a bunch of cases. Okay, so we've got a motion for discovery and a motion to strike affirmative defenses. Let's take up the affirmative defenses issues first.
Before I argue either, Your Honor, may I take 60 seconds to say where the case stands?
Sure.
So defendant's April 20 supplemental response calls this, quote, a $345 breach of contract case for a damaged suitcase. And then defendant's April 28 reply repeats that framing, calling plaintiff's recovery of $345 the only triable issue. But the supplemented record now before the court, the declaration and exhibits A1 through A7, I filed last Wednesday, tell a different story. Delta took a hard-shell carry-on bag at the jetway after I asked the agent on video for assurances of careful handling, telling him there were cameras inside, and the agent answered, yes, sir. Then Delta returned the bag to me at Austin with the shell punctured and the drone inside crushed, while other electronics packed inches away in the same bag weren't damaged. So the record is what I asked the court to keep in mind as I argue both motions today.
Okay. All right. And they're your motions. You can go ahead and let's do them.
Okay, so my motion to strike does two things, Your Honor. First, it asks the court to apply Rule 91 special exceptions to Delta's boilerplate affirmative defenses. Defenses that, as pleaded, do not give me fair notice of what Delta is actually putting at issue. And second, paragraph 17 of Delta's answer asserts the contract of carriage limitation. And I ask the court to find the defense legally insufficient as drafted because it cannot disclaim duties Delta owes independent of the contract. So there are a few things that were in defendant's reply. So Delta's December 1st response makes three procedural objections, and I want to address each of them candidly. First, Delta says Rule 90 doesn't independently grant relief. That's correct. I cited Rule 90 to preserve error, not as a vehicle, so I withdraw my reliance on Rule 90 as the basis for relief. And secondly, Delta says Rule 91 only dismisses cause of action, not affirmative defenses. That's correct as well. I would withdraw that as well. The third one, Delta cites James versus Underwood and Miranda for the proposition that defendants have no burden to plead facts in support of affirmative defenses. And with respect to Your Honor, both cases are about jurisdictional pleas. Miranda is sovereign immunity and James is judicial immunity. And neither case holds that ordinary Texas Rule of Civil Procedure 94 affirmative defenses are exempt from the fair notice. And the Texas Rule of Civil Procedures 91's own text applicable to any pleading. So it makes it clear that the special exceptions are the proper vehicle here.
Counsel response.
Like you said at the end, special exceptions are meant to launch a argument, not to provide actual affirmative relief. If that were the case, then every plaintiff after the defendant answers could be able to file special exceptions and immediately strike. He has fair notice. I mean, he was able to name each of our affirmative defenses that he wants to have stricken. So in terms of it being a fair notice rule, he had fair notice. It's a not substantive rule where affirmative defenses can be struck. And it is based off of causes of action. Those rules that he cites, 90, 91, and 91A, are all meant to provide for a vehicle of special accepting and dismissing or striking a plaintiff's causes of action, non-affirmative defenses for a defendant. At some level, an affirmative defense does not require pleading burden. It just requires fair notice, which he had. So even if the court were to want to grant substantive relief, it has already been given to him because he has notice. In other words, it would be different if we had just pled only a general denial and he doesn't know what issues we're going to bring up at trial, but he has all those issues in our pleading.
Okay, I'm going to deny the motions to strike. Let's go to the motions for discovery. Have y'all exchanged, is there any discovery going on? Any informal?
Yes, Your Honor. I submitted, there was a discovery approved from Delta that I submitted responses for back in February.
So what discovery issues are we here on today?
So I wanted to ask the court the leave to serve 8 interrogatories and 10 requests for production on Delta. 3 months ago, court granted Delta's motion to take discovery from me, and I have since responded, verified responses with a video, a transcript, photos, and receipts. I now seek narrow reciprocal discovery on facts that are uniquely within Delta's possession.
In your motion, did you set out the discovery?
I'm sorry?
In the motion for discovery, did you set out the specific discovery?
Yes, so in its February 19 response, Delta agreed to produce the contract of carriage and related documents, agreed to produce non-privileged material responsive to requests 1, 2, 4, and 5, and agreed to answer interrogatories 2, 3, 5, and 6. I do appreciate that, and I would ask the court to confirm the production on those items, and then we can address the disputed ones one by one.
Why don't you just tell me, go through the disputed ones and tell me where we are.
So the RFPs 3 and 9 and interrogatory 4, it's baggage tracking records. These are the records that show what happened to the bag once Delta took it. So bag tag number, scan location, scan timestamps, irregularity or damage codes. Delta has them, every airline has them. They're now, they're how a carrier finds a missing bag. So then it's RFP 6 and 7, which are...
Let's go back again.
Okay.
Interrogatories, what numbers?
Interrogatory 4 and RFP 3 and 9 are relating to the baggage tracking records.
4, 3, and 9?
Yes, interrogatory 4, but our request for production 3 and 9.
Oh, okay. Let's do them one at a time. Interrogatory 4, what's the issue here?
So they all stem from the same thing. They're the records of how Delta handled my bag. And I want to see if there are any irregularities. So there was a big puncture in the case. So if there was mishandling or maybe issues with equipment, I think this will help pinpoint exactly what happened. Because the damage that happened to the bag was not from careful, ordinary handling. The hard shell was punctured, so it points that something is wrong there. And I think the baggage tracking records will help us figure it out.
Counsel?
That is something that could be interesting to learn. It's just not an issue for trial. I mean, the fact is he had the bag, he got the bag, it being punctured. So what happened in the middle isn't relevant. It's only going to paint a prejudicial picture about who, what, when, the handling. And like he said, the handling records go to missing bags, and this is not a missing bag case. So if we had lost his bag, then these documents, this information would be relevant for trial, because we do need to get to the bottom of how, if there was actually negligence or if it was just a simple technological error. But this is not one of those. It's simple that he had it, it got checked, he got it, and it was punctured. So that's what we would say. Those are relevant for missing bag cases. This is not one of those.
I'm gonna approve the discovery. If there are any documents or records on that, I want them produced. And there may not be.
Just as the requests are written, or just
well, let me pull them up here. Hang on, guys. When were these filed?
1 second, Your Honor. I think it was back in February. January 28, 2026.
Okay, here I got Let's see if this is it. Plaintiff's motion for leave to conduct. Okay, let's go down individually. Interrogatory number 4. Is that
I
correct?
think, yeah, that was one of them. Yes, Your
Okay,
Honor.
let's see. Interrogatory number 4. I'll grant. What's the next one?
Part of it is request for production 3 and 9.
Okay, hang on. Let me get down to. I'll grant 3. I'll grant 9.
The next one is RFP 6 and 7. These are internal communications and training material.
Wait. What, 6 and 7?
Request for production 6 and 7.
Okay.
These are internal communications and training materials on the exclusion. Delta's August 26th denial email attached as Exhibit A6 applies Rule 17B2B, the precious items clause, and described that clause as covering high value, limited edition, or irreplaceable or difficult to replace items. But a mass produced consumer drone is none of those. And yet Delta somehow invoked the clause. So RFP 6 asks for the policy or training material Delta actually used to apply that clause to my claim. And RFP 7 asks for the internal factual communications about the denial.
Okay, I'll grant those.
Which requests? So I'm trying to find them. Sorry.
6 and 7.
Of the RFP or the ROGs?
RFP.
RP.
The next one is interrogatories 1, 7, and 8. These ask Delta to identify the people and systems involved. So the claim handler, the vendor, if any, the custodians of the records. And this is just procedural housekeeping.
Let me look through.
Yes, it's 1, 7, and 8.
Okay, hang on. 1 is granted. 7 is granted. Everything's granted. That's fine. These are reasonable.
Thank you. We have 2 more, Your Honor, RFP 8 and RFP 10.
Eight is granted. 10 is granted. Those are all fine.
Thank you, Your Honor.
Anything else?
I just had a quick follow-up on just the granting of them, which I tend to agree. We ask whether we're still, if this is more of you're granting them as they're being compelled, or that he's allowed to request them, therefore we're allowed to object or withhold based off of privilege or something like that, because some of these
you can assert any privilege you need to. Sure.
Thank you, Your Honor.
Okay. All right, guys. Thank you both.
Thank you.
Have a great rest of your Friday. Have a happy weekend.
Bye-bye.
Take care, Honor. Bye.